As Ilana mentioned, this is really a two-part series. Today I'm going to be talking about Colorado water law and just giving an overview of Colorado water law because I think it's important to have a good background as to what the law is in Colorado. Next week, I'm going to talk about the 6 major irrigation entities here in the Grand Valley that provide irrigation water to a lot of the conserved properties that Colorado West Land Trust holds conservation easements on. So obviously, a good supply of water is very important to the ag lands that we help conserve. And it's important to know how the water gets to those lands and why we have senior water rights here in the Grand Valley that are so important to protecting those lands. So I'm just going to kind of go through here. We have an hour scheduled today. I'm planning to end up about 1 o'clock. I'm hoping to leave some time at the end for questions, but if we get a lot of questions during the talk, I might not have time at the end. We'll just have to see. And so without further ado, here we go. There are really two water rights, two water rights systems that are prevalent in the United States. In the eastern United States, they operate under what's known as the riparian doctrine. And that basically means that if somebody owns land along a water course, a stream or a lake, they have a right to make reasonable uses of the water that's flowing in that stream or that's in the lake with minimal alterations to the stream system. That system works well where there's lots of water, as there is in the eastern United States. It does not work well in the western United States where water is scarce. And so in the western United States, we've adopted what's known as the prior appropriation doctrine, sometimes called the first in time, first in right doctrine. And so that's the doctrine that I'm going to be talking about today. It's what Colorado has adopted. As a matter of fact, our Constitution incorporates the prior appropriation doctrine in Article 16, sections 5 and 6. And basically those sections say that all water in Colorado is owned by the state of Colorado. It's dedicated to the public, but the Constitution gives the right to appropriate that water by diverting it and beneficially using it. And so basically what the Colorado Constitution does is incorporate what's known as the prior appropriation doctrine and gives people a chance to obtain a right to use the water, which is public property. So what I want to talk about first is how a water right is created in Colorado. And it's really very simple. There are 2 critical elements to creating a water right. The first is that you have to either remove the water from its natural course or control the water in its natural course. And then once you've done that, after you've diverted it or controlled it, you need to apply the water to a beneficial use. The statutes define a beneficial use as a reasonable amount of water to accomplish the purpose for which you've diverted it. And you have to do that without waste. You have to make an efficient use of the water that you've diverted. So let's talk about each of those elements a little bit more. I think everyone can see the cursor on my screen here. And so these photos illustrate some fairly common methods of diverting or controlling water. Up here in the upper left is a head gate. So water is flowing from a stream into the head gate. The head gate controls the water into a ditch, then takes the water to the place of use. That's a very common means of diverting water here in Colorado. You can also, in the lower left picture, construct a dam across a stream or a river to back up the water and divert the water into a headgate structure like this. This is in the lower left, the Grand Valley Diversion Dam, which I'll talk about in much more detail next week. It's on the Colorado River in Debec Canyon. Another way of controlling water in the stream is to build a dam across it and back up the water to create a reservoir. So those are all different measures of either diverting water or controlling water to satisfy the first step of creating a water right. Second step is to use that water beneficially. Historically, there were probably 4 different typical beneficial uses in Colorado, at least at the time the Constitution was adopted. Agricultural uses, domestic uses for in-house use or cities, mining uses, industrial uses. Those were kind of the traditional beneficial uses that we saw here in Colorado. But the term beneficial use is a dynamic term. It can change over time, and there's really not much of a limit on what can be a beneficial use. We have a number of new beneficial uses in Colorado. One is something called an in-stream flow use, basically to maintain stream levels in Colorado. In-stream flow water rights can only be held by a state agency called the Colorado Water Conservation Board, or CWCB. So CWCB can appropriate water rights to maintain minimum stream flows here in Colorado, or minimum lake levels. The in-stream flow uses are kind of an exception to the rule that you have to have a diversion. There's no diversion for an in-stream flow use, only the beneficial use of in-stream flow. When I was practicing, I had a number of clients that adjudicated water rights for ponds, for wildlife, or recreational purposes. So that's something you see nowadays. And there's also something called a recreational in-channel diversion, RICD, which governmental entities use to obtain water rights for things like whitewater parks or kayak parks, which are becoming much more common in Colorado. So these are some examples of new beneficial uses that you might see in Colorado. This list I've given you is by no means exclusive, and there are many more beneficial uses than what I've listed here. So when these 2 items occur, when you have a diversion and a beneficial use, that's called an appropriation of water, and a water right is created. There's nothing else that's needed to create a water right. You don't need permission from the state to create the water right, with one exception that I'll mention later. All you need to do is divert the water and apply it to beneficial use, and a water right is created under Colorado law. But in order to get plugged into our priority system, you need to take one additional action to perfect the water right and get a priority for it. As I've been alluding to here, the value of a water right is in its priority. The older the water right is, the more valuable it is, and that's because the older water rights get satisfied before newer water rights get any water. So if there's a shortage of water on a stream system, the older water rights get their water rights first, or their water first, and the newer water rights get shut off in order to provide water to the older water rights. So that's why priority is important in Colorado. As I've said, we're often referred to as being first in time, first in right. But in Colorado, our priority system is based upon adjudication of water rights in what's known as a water court. And so really in Colorado, we're first to the courthouse, first in right. And I'll go over that here in more detail and show you some examples of how priorities are actually determined.
Mark, I have a quick question
Yes, ma'am.
from Lisa Tasker. And this is your slide previous to this. She said, I have heard it said that we may never see another RICD in Colorado. Have you heard discussion of this? That's the recreational in-channel diversions.
I have not heard that, and new RICDs are being created regularly. The Garfield or Glenwood Springs has one ongoing now. I'm not sure if they've gotten the decree for it yet or not, but they're looking for an RICD in the Glenwood area. And so I have not heard that. And in fact, my experience shows just the opposite, that they're continuing to be created.
Thank you.
Okay. So just a quick summary, and this bears repeating, that to create a water right, you need to divert or control the water in its natural course and apply it to beneficial use. And then in order to perfect that water right and get a priority for it, you need to adjudicate it in water court. Before I get into the adjudication process, I just want to talk a little bit about different types of water rights that you might hear about in conversations. One way to talk about water rights is to refer to them as being either absolute or conditional. An absolute water right means that you've completed both of those steps. You've diverted the water and applied it to beneficial use. That's the appropriations completed. It's called an absolute water right. On the other hand, if you've just started the appropriation but not completed it, perhaps you've gone out and started to dig your ditch, but you haven't actually completed the ditch and applied the water to your fields, you can obtain from the water court a priority for a conditional water right. The water right is conditional upon you completing the appropriation within a reasonable time period. And if you get a decree for a conditional water right, you have to come back into water court periodically. Currently, it's every 6 years right now, and show the water court that you're diligently pursuing the completion of the appropriation. Once the appropriation is completed, then you can convert the conditional water right to an absolute water right, but you maintain the priority of the conditional water right. And that's sounds kind of complex, but I'll show you what that means here in a little while when I talk about how priorities are actually determined. So absolute versus conditional is one way to talk about water rights. Another way is to characterize them as being either a direct flow water right or a storage water right. A direct flow water right is water flowing in a ditch or a pipeline or out of a well. And the rate of flow of such a water right is usually described in terms of either CFS, which means cubic feet of water per second past a certain point, or gallons per minute. And then storage water rights are describe water rights that are water that's stored in a reservoir or a pond. And they're described in terms of the volume of water that's stored, and the typical unit of volume is the acre foot. So what does that mean? 1 CFS equals about 450 gallons per minute. And 1 acre foot of water is about 326,000 gallons. So it's the amount of water that you'd use to cover about 3/4 of a football field, 1 foot deep. And you can convert one to the other. 1 CFS of water, 450 gallons per minute, flowing for 24 hours equals about 2 acre feet of water. So those are typical units that are used in talking about water rights here in Colorado. Another type of water right is an underground water right. In Colorado, we have water both on the surface and underground in aquifers. And in Colorado, our surface and groundwater systems are integrated. The underground aquifers actually support the surface water flows. If you deplete the aquifers, and the surface water sinks into the ground and becomes groundwater, underground water. And so we treat both the surface and the groundwater as one system. All water is presumed to be tributary, so the underground aquifers are presumed to be connected to the surface waters. And underground water rights are the exception to the general rule. In order to appropriate an underground water right, you do need a permit from the state first before you can do an appropriation of an underground water right. And the reason for that is the state wants to make sure that there's no injury to other water rights. If you start pumping groundwater, it can have delayed impacts that might not be felt for years down the road on surface water rights. And so the state will have certain things that you need to do in appropriating an underground water right to make sure that you don't injure surface water rights. And I'll pause every once in a while, Ilana, and if there's a question, just pipe up.
It looks like we're good for now. Thank you, Mark.
Okay, good. I'll keep plugging along. Okay, so now that we've got the basics out of the way, let me talk a little bit about how you get a priority for a water right, how you adjudicate it in court. We currently operate under a statute known as the Water Right Adjudication and Administration Act of 1969. Water attorneys generally just refer to this as the 1969 Act. The 1969 Act established 7 water divisions around the state that correspond to the major river basins in Colorado. This is a map of the 7 divisions. There are 3 water divisions on the Front Range, the South Platte, the Arkansas, and the Rio Grande, and then 4 on the West Slope. The Yampa White is Division 6, the Colorado is Division 5, the Gunnison River Basin is Division 4, and the San Juan and Dolores River Basins down in the southwest part of the state are Division 7. Grand Junction is kind of on the dividing line between the Gunnison and Colorado River basins. And so the water rights that we have here in the Grand Junction area are either going to be in the Division 4 Gunnison River Basin or Division 5, the Colorado River Basin. So each of the water divisions has a division engineer. The division engineer is a state official who administers water rights. So if a senior water right is not getting the water that it's entitled to, the division engineer has the power to go and shut off junior water rights, the more recent water rights, to make sure that the senior water rights get the water they're entitled to. And then each division has a water court where water rights are adjudicated. And each water court has a judge, a referee, and a clerk who does all the paperwork for the court system. So how do we go about adjudicating a water right? It's really pretty straightforward. If somebody has a water right that they want to adjudicate and get a priority for, that person prepares and files an application with the water court. The application will state the location of the water right, where it's diverted from the natural stream, the uses of the water right, the amount being claimed, and any other relevant information relating to the use of the water. The applicant will then file that application with the appropriate water court. If the water is being diverted out of the Colorado River or one of its tributaries, they'll file the water right application in Division 5 because that's where the water right is located. Once and the water court operates on a monthly basis, so it will take all of the applications that were filed in 1 month and prepare a summary of those applications. Actually, the applicant prepares that summary, but the water court will collect all those summaries and publish what's called a resume. That resume is published in the newspapers in the areas where the water rights are located and also on the web. And so the resume will give the summary of all the applications filed in a particular water court in a month. And so once that resume is published in the newspapers, there's essentially a 2-month waiting period. And during that 2-month period, if somebody feels that their water right is going to be injured in some fashion by the water right being claimed in the application, they can file what's called a statement of opposition to the application. Now in Colorado, we have a very wide open standing rule on water rights. If someone wants to oppose a water rights application, they don't have to own a water right that's going to be injured by the application. In essence, in Colorado, anybody can file a statement of opposition or oppose any application that's filed in Colorado. Normally, that doesn't happen. Normally, statements of opposition are filed by other water rights owners who feel that they could be injured. But sometimes Organizations such as environmental organizations may come in and oppose an application filed by an industrial outfit, and they'll use their statement of opposition to try to put limits on the industrial application that's being filed. So, but normally a statement of opposition is going to be filed by another water rights owner out there. If no statement of opposition is filed to an application, then the application will be reviewed by the division engineer and by the water referee. And if everything is in order, the referee will issue what's called a ruling of referee, granting the water right and granting a priority to it. The ruling of referee then goes to the water judge, who will review it, make sure everything's in order. And if it is, then he'll confirm the ruling and make it what's called a decree of the water court. So you'll often hear about water court decrees. That just basically means that the water judge has confirmed the water right and confirmed that the steps have been taken to create either a conditional or an absolute water right. If a statement of opposition is filed, then the applicant has a couple of options. Number one, the applicant can try to work with the opposers to settle their concerns and come up with terms and conditions that would apply to the water right to alleviate the concerns of the objectors. Or the applicant can decide to go to trial before the water judge. A water court trial is conducted like any other civil trial. The applicant will be considered the plaintiff, the opposers are the defendants, and it's just tried to the water judge. There's no jury in a water court case. And after the trial, the judge will either deny the application or confirm it. He may confirm it with conditions to protect the opposers, or he may confirm it without any conditions. Now in Colorado, there are many, many applications that are not opposed. It's not at all unusual to have an unopposed application. And even if an application is opposed, the great majority of cases are actually settled without going to trial. I practiced water law for over 30 years, and in that time period, I probably had half a dozen trials, things that actually went to trial that couldn't get settled. So if you work at it, it's pretty common to get opposed cases settled here in Colorado. Now, the effect of an adjudication, this process that I just described, the end result, as I said, is a decree from the water judge. That decree will confirm the water right and confirm the priority that's, that water right has in our priority system. As I've said a number of times, the principal value of a water right is in its priority. Older is better. And so let's talk about what that actually means. In Colorado, the priority of your water right depends on two things. The first and most important thing is the year in which the application was filed with the water court. That's called the adjudication date. And so it's not the year that the decree was entered. It could take several years from the time an application is filed until the decree is actually entered. The determinative factor is the year in which the application was filed. It doesn't make any difference whether you file it on January 1st or December 31st. Any application filed in a year is, any time during the year is deemed to be filed in that year. And the second thing that a priority is dependent on is the appropriation date. The appropriation date is basically the date on which the first work was done to start the appropriation. So it might be the date that you went in and put a stake out on the stream bank saying, this is where I'm going to put my ditch. It may be when you started to dig the ditch. It's the earliest date that you can justify as a date when you actually went out and started physically doing something to appropriate the water. And I'll give the general rule, and then we'll go to the next slide and I'll show what that general rule actually means. So water rights based on applications filed in 1 year are junior to water rights based on applications filed in previous years. So if somebody has an application for a water right that was filed in 2020, that water right will be junior to applications that were filed in 2019, 2018, 2017, on and on backwards. And then there are hundreds of water rights filed in each division each year. And so how do you determine the priority among those hundreds of applications that are filed in any particular year? You use the appropriation dates. So let's look at some examples as to what that actually means. So here I have a chart, and I have 6 different water rights listed on the chart in order of their priority, from priority 1 to priority 6. So let's look at priorities 1 and 2. They were both have adjudication dates of 2007, which means that the applications for these water rights were filed in 2007. So they both have 2007 base priorities. How do you rank them one against the other? You look at their appropriation dates. So priority number 1 started his appropriation back in 1998. Priority number 2 didn't start their appropriation until 2002. So based upon the appropriation dates, this water right is the first priority. This is the second priority. So that's pretty straightforward. Let's go down to the next 2 water rights, 3 and 4. You'll see that they both have adjudication dates of 2008. Again, that means their applications were filed in 2008. In order to rank them against each other, you have to look at their appropriation dates. And here you'll see that their appropriation dates are pretty close together in time. They both were in 1995. So when you see an appropriation date in a water rights decree, it will also always be a specific day, because you have to get more specific than just 1995. Here, priority number 3 started work a little bit before priority number 4, so priority 3 gets a little boost in his priority. But even though he started his work in 1995, he delayed coming into water court until 2008. And so even though he has a 1995 appropriation date, he's junior to these 2007 priorities. So that illustrates the importance of coming in and filing your application with the water court just as soon as you possibly can. Now we go down to the last 2 priorities, 2009 application dates. Because they delayed until 2009, they're junior to the first 4 priorities here. And you'll see that priority number 5 actually has an 1888 appropriation date. That's not a typo. I had that situation come up one time where a ranching family had a stock water right that they had been using since the late 1800s, but they had delayed in coming into water court to adjudicate that water right. And so they were granted a very junior priority. They lost over 100 years of priority because of their delay in coming into water court to adjudicate the water right. And then priority number 6 was a 1990 appropriation date. So even though 1990 predates all these other rights except for the 1888 right, it's the last in line because they delayed in coming into water court to adjudicate their priority. So in summary, it's not first in time, first in right in Colorado. It's first to the courthouse, first in right. So keep that in mind if you have a water right and you're delaying in coming into court. Okay, let me talk about a couple of additional limitations when you go into water court and want to appropriate a conditional water right. You have to prove to the water court that you're actually going to divert that water and beneficially use it, and that you're going to do that within a reasonable period of time. That's called the can and will doctrine. That's generated a lot of litigation. When you're looking at can and will, you look at things like, does the appropriator have the financial capability to do what he wants to do? Does he own the land? Can the water be beneficially used? How long is it going to take to build the project? And so this creates a lot of litigation opportunity for opponents of water rights that are being claimed. And then we also have a doctrine in Colorado called the anti-speculation doctrine. And basically this means that somebody can't go out and try to get an appropriation for water that that person can't actually use, or that entity can't actually use. So I couldn't go out on the Colorado River and try to do a conditional water right for 100 CFS saying, I want to appropriate this water and I hope to be able to sell it to the city of Grand Junction down the road to meet their needs. The court won't let somebody hoard water rights like that. In order to obtain a decree for your water right, you have to show that either you personally have a right or the ability to use that water and that you will be using it, or that you have a contract with somebody that is willing to buy the water from you. Cities, of course, and water districts provide water to their residents. Irrigation companies, like I'll be talking about next week, provide water to their shareholders and landowners, and so they have a little different rule. They can of course appropriate water for their users, but they have a financial fiduciary responsibility to those users, and so there's a relationship there. It's not a hoarding situation like the 100 CFS that I described. So the anti-speculation doctrine is an important doctrine in Colorado and overlays our whole water rights system. You have to actually have a defined use for the water right yourself or for the people that you're serving. So I'm going to talk about a... Yes.
Before you go on to the next slide, we have another question.
Yes, good.
This is from Helen Love, and her question is, how does this, what you were just talking about, impact recent speculative purchases of land from owners? Obviously, there has been concern that water will be sold elsewhere. I think you're probably familiar. I'm assuming, Helen, this may be referring to some of the purchases by WHAM that have been in the media lately. And yeah, how does that tie into this speculation, anti-speculation doctrine?
That's an excellent question, and it's one that's generated a lot of talk and a lot of concern in Colorado. In the 2020 legislative session, there was a panel that was created by a bill that passed that is actually looking at that issue and looking at the anti-speculation doctrine in Colorado to see if it should be strengthened to address situations like that. And the situation that Helen is talking about is there's an outfit called Water Asset Management, or WHAM, that has come into the Grand Valley and is buying up farms in the Grand Valley. They're continuing to be rented out, the farms are, so the water is still being used. But WHAM is, as I understand it, basically a hedge fund from back east, and they buy assets like this to make money in the long run. And the concern is that they're buying these lands in order to strip the water off them somehow in the future to sell that water separate and apart from the lands. That technically is not what the anti-speculation doctrine is getting at. The anti-speculation doctrine is getting at the initial appropriation of the water right. And here the water has been appropriated, it's actually being used on the property. And so the water is not being used for a speculative purpose. At this time, it's being used for this decreed purpose, irrigation. The speculation comes in about what's going to be done down the road for that water and selling it to somebody down the road that may need it in the future that will generate returns for this hedge fund. I think it's going to be a really interesting issue. In Colorado, water rights generally are saleable separate and apart from the land. There are some exceptions to that, and I'll talk about that a little bit next week in my talk. But oftentimes, water rights will be sold by a farmer or rancher to a city when the farmer or rancher doesn't want to conduct business anymore. It's a valuable asset for that individual. It's basically that individual's 401k plan to be able to sell a valuable asset. And so I think we have to be careful about putting limitations on what WHAM is doing, because it could, if limitations were placed on that, it could have lots of impacts on ordinary farmers and ranchers who have a valuable asset that may not be saleable in the future. So that's a pretty long-winded explanation. The short answer is the anti-speculation doctrine that I mentioned doesn't apply to that situation, but there is a speculation aspect to people coming in and purchasing lands like this.
Thank you, Mark. I'm sure that could be a whole, hour discussion in and of itself, but I appreciate your response to that.
It certainly could. And it's a tough nut to crack. How do you put limitations on this without hurting innocent water rights owners?
Right.
Assuming that the hedge fund is not innocent. And I'm making generalizations there that I probably shouldn't make. But okay.
Thank you.
You bet. Any other questions? No? Okay.
Nope.
So let me talk about changes to water rights, because Helen's question kind of feeds into that. As I mentioned, water rights can be sold separate and apart from the land generally. And a water right owner has a right to make changes to his water right. He can sell that water right, and it can be changed from, for example, an irrigation water right to a domestic water right. In Colorado, if you want to change your water right permanently, you need to go to water court and get approval to do that. And what the water court will look at will be to make sure that there is no injury to other water rights because of the change that's being proposed. Basically, when you change a water right, you're limited to changing what's called the historical consumptive use, or HCU, of that water right. I've got a slide. My next slide here will show this in a little more detail. And you also need to maintain the return flows that have been historically flowing to the stream from your use of the water right. So I'll explain that here in just a minute in more detail. But you can change a number of aspects of your water right. You can change the use of the water right. You can change the point of the diversion of the water right, where it's diverted out of the stream. You can change the place of use from a field to a city. You can change any aspect of a water right, but in order to do it permanently, you need to go to water court and get water court approval. So this is a slide that a client of mine prepared for me a number of years ago. And I've always liked the slide because it's a pretty good illustration of the limitations that you have in a change of water rights case. So in this case, we have a river, the Good River, flowing down this way. We have a ditch that comes out of the river up here and flows over to an irrigated field. The water from the ditch is put into furrows on the field, flows across the field to irrigate the crops on the field. And the water from the irrigation is collected in a tail ditch that then goes back into the Colorado River and takes the extra water back into the Good River, I'm sorry. And so when you irrigate a field like this, there will be two aspects to it. One aspect is the consumptive use from this irrigation. Some of this water will evaporate, some of it will be taken up into the plants and used by the plants. That consumptive use is water that doesn't make its way back to the stream. So the stream flow is depleted by the amount of this consumptive use. The second aspect is the return flow aspect. And basically, when you irrigate a field like this, as I mentioned, some of the water will stay on the surface and go into a tail ditch and go back to the river. Some of this water will sink into the ground and flow back to the river underground. The combination of these two things are called return flows. And the importance of return flows is that they help maintain the flows in the stream. And so if you have a downstream water right down here that relies on both the natural flow in the good river and then the return flows from this irrigation. And so if the owner of this field wants to sell his water right to the city of Grand Junction, somewhere along the Good River, then the only thing that this owner can sell to the city is the consumptive use, because that's water that's not used by other water rights here. If he sold the return flows and the city could get both the return flows and the consumptive use, then this downstream water right would be hurt because he would no longer be able to use the return flows that historically flowed down to his water right. So in a change case, the important thing is to maintain the historic conditions that flows to this water right down here. And so that means that in a change case, the only thing that can really be changed for another use anyway is this consumptive use portion, what the plants actually use and what was evaporated. Water rights engineers have certain formulas that they can use to determine what that consumptive use is. It's based upon the elevation of the land, temperatures, the crops grown, soil types, things like that. And so it's a fairly complex determination to determine what the consumptive use is, but that's what's going to be looked at in a change of water rights case. I mentioned that if you wanted a permanent change, which normally a city will want if they're buying an agricultural water right, you have to go to water court. There are some statutes that allow temporary changes. There's something called a substitute water supply plan, where a water rights owner can do a temporary change of water rights, usually no longer than 5 years in duration. There's a process set up with the state engineer's office to give notice to interested parties, and the state engineer has to approve it and make sure there's no injury to any other party if they do a temporary change. There are also some statutes on loaning agricultural water rights for ag purposes and for in-stream purposes. Again, those loans are on a temporary basis. They're not on a long-term basis. Augmentation plans. We're getting down to the end. I'm going to talk about two more things, and then we have a little time for additional questions if need be. In Colorado, we have something called an augmentation plan, and the statute says an augmentation plan is a detailed program to increase the supply of water available for beneficial use. And basically what it allows is for a junior water right to continue diverting water when a senior water right is calling for water. When a senior water right hasn't been satisfied and places a call on the stream to shut off junior water rights, an augmentation plan will allow a junior water right to continue diverting. And this slide illustrates how a typical augmentation plan may work. So you have the junior water right upstream here, you have a senior water right down here, and if the senior water right is short on water, he can place what's called a call on the Colorado River and shut off any junior water rights upstream to shut off their water use and allow the water to flow down to the senior water right owner. Now, this junior water right owner, if he wanted to keep diverting water when a call is on the stream, he might go and buy water from this reservoir here. And if a call is placed on the stream, then he could call for his water in the reservoir to be released down to the senior water right. And then the junior water right holder could continue diverting an equivalent amount of water out of his junior upstream point of diversion. So reservoirs are nice for using in augmentation plans because they store water early in the season. Once water is stored in the reservoir, then it's there for future use. That doesn't have to be released onto a senior water right. So reservoirs are often used by junior water rights owners to release water to a senior water right so the junior can keep diverting. There are other types of augmentation plans, but this is really the most common type that you'll see in Colorado. And then the last thing I wanted to mention was abandonment of water rights. As I mentioned at the very beginning, a water right is a right to use the public resource here in Colorado. The law says that you can continue to use your water right as long as you need it. But if you no longer need it, or if you stop using it, then there are other people out there who probably have a need for it. And you shouldn't be able to hoard that water if other people need it and you don't. So in Colorado, water rights can be abandoned in whole or in part if two things are shown: that the water right's not being used and that there's an intent never to use the water again. Obviously, non-use is pretty easy to show. It's the intent factor that creates all the litigation that we have over abandonment of water rights, because intent is up here. It's kind of hard to prove that. You have to look at other factors to try to prove what intent is. But if someone is able to prove that water rights have not been used, or a water right has not been used, and the owner never intended to use it again, then the result is that that water right is terminated, or a portion of it is terminated, and the water goes back to the stream for the next person in line. In Colorado, one water right owner can sue another water right owner saying your water right's been abandoned. That doesn't happen very often. The typical way for abandonment in Colorado is something called the abandonment list. And the statutes say that every 10 years, the division engineer in each division has to come up with a list of all of the water rights, the absolute water rights that have not been used in that division over that 10-year period. And then he publishes that list, and the water rights owners can contest the inclusion of their water right on the list. But if they don't contest it, then at the conclusion of the abandonment list process, the water rights that remain on the list are considered to be abandoned. So that happens every 10 years. We're in an abandonment list year now. 2020 is an abandonment list year. So in July, the division engineers publish their abandonment list, and there's a 1 or 2 year process for people to say, no, my water right doesn't belong on the list, take it off. And so there will be a couple year process here before that 2020 abandonment list is concluded. So I think that's all I have. Yep. So if there are any other questions, I'm happy to answer them. Next week, we'll be talking about how some of these water rights issues apply here in the Grand Valley with the 6 major irrigation entities that have appropriated water rights for their users.
Thank you, Mark. We had a quick question from Jane, just asking if this will be recorded. And yes, it was recorded. And Mary and Dylan, I know, are working on getting the recording of these webinars eventually put up on the website, or we'll figure out a way to share it so it will be available to everyone. People feel free to dive in with other questions. Mark, I have a question for you. This is something I've just been curious about. There's, a lot of talk, obviously, that the Colorado River has been over allocated, and there's, not as much water in the river as we have claimed there is. So what is the process that Colorado still has for continuing to adjudicate and appropriate water rights? If we feel like there isn't enough water in the river for what we already have claimed, how can we continue to give out water rights?
That's a really good question also. That implicates interstate issues because the Colorado River is an interstate stream. There are 7 states that rely on the Colorado River water flows. And there are compacts, court decrees, a whole law of the Colorado River that divvies up the Colorado River. And so in order to answer your question, you have to look at 2 things. One is the intrastate aspect of it, just the Colorado aspect of it. And there is still water available in Colorado for appropriation. For example, below Grand Junction, the Colorado River flowing past Fruta and down to the state line still has a lot of unappropriated water in it, at least for Colorado uses. However, overlaid over that is the interstate aspect of it. And that's where things become a lot more unclear. We in Colorado have an obligation to send a certain amount of water downstream for downstream states to use. And so even though there may be water available vis-a-vis different Colorado users, there may not be enough in the stream system to satisfy our obligations to Arizona and California. And so you're right, we're in a 20-year drought now, 21-year drought on the Colorado River, and flows have decreased dramatically over the last 20 years. And so there are lots of issues now about how the upper basin states relate to the lower basin states. And there may not, when you look at the interstate aspects of it, be any more water available to appropriate in Colorado and still maintain our obligations to California and Arizona. That's another one of these topics that could take a whole hour to discuss. But the simple answer is there's water available. If you just looked at Colorado, there's still water available. But if you throw in the other states, there may not be.
Obviously, a very complicated grid of water and requirements that we have to meet as a state as well.
Yes.
We have another question from Steve. Under which Grand Valley irrigation systems are lands being purchased by WAM? I don't know if you know the answer to that.
It's basically two irrigation entities, I think, the Grand Valley Water Users Association, which operates the Grand Valley project, and then the Grand Valley Irrigation Company, which is the oldest irrigation company here in the valley. So they're both on the north side of the river. I haven't heard of them purchasing any major assets in either out in the Redlands or on Orchard Mesa. So it's basically Grand Valley Water Users and GVIC.
Thank you. Well, we are at 1:02, and I know some people have to get back to work and other priorities in their life. But if people have questions, I'm okay to stay on for another couple minutes. And Mark, if you have another couple minutes, people can keep asking questions. But I really appreciate, Mark, your time today. This was interesting. Every time I attend a water seminar, I always glean a lot of information. So I appreciate it. And I look forward to next week as well. And I hopefully most of you can join us for that. I think that will be really interesting. And for those of you that live in or around the Grand Valley, really relevant to the lands that you see and a lot of the conservation work that we do here at Colorado West Land Trust. Let's see. Oh, I have one more. So thank you all. Feel free to head out if you need to. I do have one more question from Jane. And her question is, where would a person go to find out if their water right is recorded in the water court?
The easiest way to do that is probably to contact the division engineer's office in the division in which the water right is located. You can find it on the state engineer's website, but you kind of have to know what you're doing to do that. And so the easiest way is to contact the division engineer's office.
Great.
And in Division 5, the Colorado River Basin, that's in Glenwood Springs. In Division 4, the Gunnison River Basin is in Montrose.
Great. Thank you. Well, we have a lot of people. Mark, I don't know if you can see the chat box, a lot of people saying thank you for the presentation and for the information. So yeah, thank you very much. And thank you all for participating. I don't see any more questions coming in, so I think we can sign off and hopefully we'll see a lot of you next week. Feel free to follow the link that Mary put up on the Colorado West Land Trust website to join us for Mark's presentation part 2 next week and our 40th celebration.